I'm Francesca Palmiotto, and I'm assistant professor of law and new technologies at the IE Law School University in Madrid. I've always been a criminal procedural lawyer. When I was working in the law firm, public prosecutors were starting to use different types of technologies. We didn't know what kind of system, how the system was working. Of course, it was starting at the investigation phase. Then the results of this computer system ended up at trial as evidence. It seemed like a bit of a sci-fi situation. And I was like, no, actually I saw that happening, it's real. We cannot allow junk science to enter criminal proceedings. How can we make the right to confrontation meaningful enough in the age of AI? Law is not just what is written in the books. Law is the result of a political compromise. I found more problematic the practice of the law than the law in itself. That's also the role of procedural law, to set boundaries and standards for this type of evidence. And when we think about AI systems, you are being treated as a number. So you're a percentage. You have a right to procedural fairness, to a fair trial. Therefore, you must access AI evidence. That's simple as that.
What is the message to anyone who will listen to this podcast?
That's a tough question.
Welcome to the JUST-AI Jean Monnet Podcast, where esteemed experts from across the globe address the most pressing issues on AI technologies, their regulation, and the resolution of disputes involving them. If you are a migrant, worker, civil servant, or hold any role where AI systems process your data such as country of origin, gender, or age, does the law provide procedural mechanisms allowing you to verify the accuracy of that processing? Do the existing legal frameworks offer sufficient rights and remedies to make sure that your voice is being heard should you disagree with an AI-generated output about you? The critical themes of AI accuracy and trustworthiness, effective judicial protection, and the dignified treatment of individuals affected by AI-driven decisions were at the heart of this episode of the JUST-AI Jean Monnet Podcast, featuring brilliant Francesca Palmiotto, professor at IE University, Madrid. Drawing on her extensive experience as a practicing criminal lawyer and researcher focused on the intersection between criminal law and AI, Francesca stresses that the law needs to be braver and bolder in setting tangible limits for AI systems. A vivacious advocate for effective procedural fairness, in this episode, she shares her perspective on how AI regulation should enhance the meaningful judicial participation of people impacted by potentially harmful AI outcomes. Join us as Francesca highlights compelling and thought-provoking issues surrounding AI's influence on procedural law and fairness, and offers key recommendations for improving the regulatory landscape.
Welcome to another episode of the JUST-AI Jean Monnet Center of Excellence podcast. I am beyond thrilled today to welcome Professor Francesca Palmiotto, who is one of my kindred spirits in terms of our research interests and the topics that we cover in our respective research. So, Francesca, welcome. We are more than happy to have you on this podcast.
Thank you.
And I think that we will have a very, very stimulating and very interesting conversation that is completely in line with also the research that we're trying to develop at the JUST-AI Jean Monnet Center of Excellence. So very briefly, could you give us, this is the first question that I always ask to our guests, could you present yourself for our listeners and viewers?
Thank you. Thank you so much. So first of all, I'm also beyond thrilled to join this podcast, and thank you so much for the invitation. So I'm Francesca Palmiotto, and I'm assistant professor of law and new technologies at the IE Law School University in Madrid. Before joining IE, I was working on the AFAR project, which stands for Algorithmic Fairness for Asylum Seekers and Refugees, at Berlin. I'm actually currently in Berlin at the moment, so my old home, let's say. And the project was hosted at the Hertie School, where I stayed for 2 years and did research on the area of new technologies, immigration and asylum governance. So let's say my research generally focuses on AI and human rights, broadly speaking, but more specifically on procedural fairness, which is precisely where our research interests meet. And that's why I'm also extremely honored to be hosted as such an important center like JUST-AI. So thank you again for the invitation.
Well, thank you, and indeed, as you kind of alluded to, there are not many scholars. I mean, the procedural fairness scholarship in connection to AI, I feel, is starting to emerge and is starting to grow, but there are not very many of us who approach artificial intelligence from the perspective of procedure.
Absolutely.
So, in line of that, kind of argument, or in that line of ideas. Your PhD was completed at the European University Institute in Florence. It's titled Artificial Intelligence and Transformation of Criminal Trials, Preserving Fairness in Europe. And already that is kind of curious for me, because very early on, you wanted to explore artificial intelligence, but you wanted to explore it in the context of criminal law and criminal procedure. So what triggered that interest to relate the two,
Yes. So actually, I am a criminal lawyer, let's say, or at least my background is in criminal law. Since I was little, I wanted to become a public prosecutor, things like that. So that was my dream. And then life brought me to academia somehow. But I always been a criminal procedural lawyer. So after the university, I started to work in a law firm, in a criminal law firm, because my passion was procedures and criminal law in particular. And when I was working in the law firm, which by the way was kind of my dream job, and I really, I really loved it, we started to see as defendant lawyers that public prosecutors were starting to use different types of technologies, at the time not really AI technologies, but let's say computer systems, software for many different purposes. And what we realized as lawyers is that we did know that somehow they were using these systems, but we didn't know how, what kind of system, how the system was working. And most of the time, even if, of course, it was starting at the investigation phase, then the results of this computer system ended up at trial as evidence. And of course, in the reality of a law firm where you're working on so many different cases and so on, probably it's not your priority to, really understand how the system works and challenge the specific type of evidence, especially at the beginning of the criminal process, right? So you have other priorities, obviously, which is fair. But that's topic really caught my attention a lot. And I realized that it was something I couldn't find much in the literature, especially in terms of how can you meaningfully challenge these type of tools, so the procedural fairness aspects, right? And that's where I realized, well, probably it is a topic that needs a different kind of reflection and work, and that's why I proposed my PhD. So actually the idea started from living firsthand how defense lawyers and defendants have no clue about how the system works, and we do not have, let's say, actionable laws and regulations that we can use to kind of trigger the sufficient level of participation that, in my view, as a procedural fairness lawyer, you would need to have. So that's where it started. And to be fair, at the beginning, when I was doing the PhD, the topic of AI and criminal justice was quite controversial in the sense that, from a very theoretical perspective, what was starting to happen was legal scholars working a lot on criminal liability and AI.
Yeah.
So that was something that was, already going on, but the procedural side of things was quite unexplored. And at the same time controversial because, it seemed like a bit of a sci-fi situation. And I was like, no, actually I saw that happening, it's real and it will increase in the future. And I'm talking about, 2018, where the AI Act was not there yet, and then 2021, the proposal. So that's where I realized, this is really a field that needs more engagement from legal scholarship. So that was kind of the motivation. But I have to say, it was not easy as a procedural lawyer to make, clear that this is a problem of social relevance, and it will come. Member states will need to address procedural law questions because this system will enter criminal trials, at some point. And I think now we are at a stage where it's quite clear that this is happening. So in that sense, it was quite interesting to do a PhD on that. But what prompted my research was really a first-hand experience.
Yeah. And in the PhD, is there, what do you suggest, what do you propose, what is the normative claim in terms of how procedures should be regulated and maybe how courts should approach, evidence that is essentially AI output,
Yes.
Are there any, do you reflect on those questions?
Yes. So actually right now I'm working on the first monograph from the PhD, and this is precisely the last chapter, which is more the normative directions. So what was interesting was also to see the development of the AI Act. And of course, one of the claims I make is that, in Europe, EU law will actually have a huge impact also from a procedural perspective. So even if, criminal law is something that we perceive as very national, actually EU law, and I'm not just talking about the AI Act, but also, of course, data protection law has a procedural impact as well that we need to take into account. But at the same time, my proposal is to kind of encourage member states to be brave and regulate these tools even further in the criminal law field, at least, or in the criminal procedural field, by setting very specific requirements in terms of admissibility. So the broader question would be, what kind of AI systems can we allow, right? So, and there are many different ways in which you can approach this question. From a legal perspective, we already have a lot of experience with scientific evidence. So of course, that should be, in my view, certain standards, right? So we cannot allow junk science to enter criminal proceedings. So we don't do that with human experts. Why would we do that with AI systems, right? So there is this sort of, encouragement to apply concepts and procedural law principles that we already tested with other types of evidence and uphold AI evidence to the same standards. Because from a more empirical perspective, what I see in my research is the impact that the hype on AI system has also on legal practitioners kind of blinds us to some extent. So we need to be aware of the limitations of AI. So that would be the first level, admissibility rules. The second level, which I think is something, of course, very interesting for the center as well, and core of your research too, is how can we make the right to confrontation meaningful enough in the age of AI? So do we need to rethink about the right to confrontation, the right to examine adverse evidence? How can we, manage that? Because traditionally, when there is a witness or an expert witness, you put them on the stand and orally question them, right? You can't do the same with AI system. So how can we make a new implementation of these principles with law, with procedural law? So that's the other question. And I propose ways to do that. And that was an interesting part of the research because it had to be necessarily interdisciplinary, in the sense that I think the law needs to meet not only computer science, but in this case also forensic science, in understanding what are the techniques that allow us to actually make the system transparent or explainable, also testing techniques. So that's where I also engage a lot with forensics experts. They have longstanding experience in court. in really making them simple questions like, I have a system, how do you prove it's accurate or not? So we dialogue together, and that's where I think the law needs also to take into account the insights for different disciplines. So I make proposals in that sense, but of course these are my proposals as a legal scholar, but it does make my thesis kind of a set of policy priorities in that sense. So admissibility again, and confrontation. How do we update these procedural concepts to the age of AI? And I make proposals in that sense for the field of criminal law. Yeah.
Yes, that is fascinating. I do hear you and agree with you in the sense that I think one of the things that I am struggling with and also playing with a little bit in my own research is actually the issue of accuracy standard of evidence, right? I mean, that is something that in the emerging AI liability case law, I have been able to detect as a nascent court trend, in the sense that as you say, for scientific expertise, most jurisdictions have already tests that they can apply to verify the accuracy and the trustworthiness of scientific expertise. So courts seem to assimilate AI output to scientific expertise, but still we need additional standards in terms of how to assess the trustworthiness and the accuracy of something, and it's a question of admissibility, as you say. So at what point can you consider that AI output is evidence in a legal sense, and at what point can you disregard it as such? And then, but following up on that, I think one of a field of your research where you actually addressed this issue was migration, and I refer to the just a marvelous article that was published recently in the German Law Review that focuses, it seems to me, on national but also European cases of in the field of migration, but mostly in the treatment of asylum seeker applications and how those processes were automated. So could you tell us a little bit more about that, and how AI output in those cases was or was not considered as trustworthy and accurate evidence?
Sure. So as I said, before joining the IE Law School, I was a postdoctoral researcher of the AFAR project, which is hosted the Hertie School at the Center for Fundamental Rights. Yeah. And the aim of the project is to investigate fairness in many different dimensions of fairness, which is not just procedural fairness, which was, let's say, my core aim, but also distributive fairness, remedial fairness, perception of fairness, but very different dimensions of fairness in the field of migration and asylum. And our first output was a mapping report, which was led by my colleague Daria Outschool, where it was extremely difficult actually to release that report, because our idea was we first need to have an empirical overview of what kind of systems are used, why and when, and for what purpose. So the aim of the report, which is publicly available, I invite you to take a look at it, is precisely to do that, to have a mapping, an idea of how asylum and migration procedures are being automated. And from there, I took all of these empirical insights to pose a kind of, if you want, simple question, which is, when is a decision automated? So, because that's also a kind of a legal doctrinal question that is haunting us. So when we talk about, automated systems, we first need to kind of find them the right legal definition, in the sense that we have this general provision under international law and EU law of solely automated decisions are simply prohibited. And of course, we have exceptions in the GDPR and so on, but the general principle is that. But, we need to make a distinction between what is a decision and what else the automated system is actually doing. And that's kind of what I try to claim is we are using certain systems not necessarily to take final decisions, but as evidence, right? So, and when we talk about evidence in the field of migration and asylum, there are many different ways in which AI systems and automated systems more broadly are used. One of which I think is very controversial to some extent and raises many questions that we both are very interested in, which is in the asylum process, the use of automated systems to produce evidence about the country of origin of the asylum seeker.
Yeah.
And there are many different ways this is done. So one way is, for example, very controversial practice in Germany. If somebody does not have sufficient documents, they would take their phone, basically use a computer run by AI to read out all the data within the mobile phone and then make a report with statistical likelihood of their country of origin. So, for example, it would use, IP addresses or the ID of the calls, geolocation of the pictures, and so on, to kind of determine what is more likely your country of origin. And this is then used, however, and then it kind of changes the evidential value that this report has throughout the procedure, because most of the time, then this evidence is used as evidence of the fact that the asylum seeker is not credible.
Yeah. Yes.
So if somebody claims I am from, let's say, Italy, but then, of course, no, but I'm just saying, of course, no, but yeah, I come from this country, right? But the report said, no, you're actually not from Italy. Then this is used as evidence that I'm not credible, right? So this is also how, kind of a function creep also of the system that can be used to prove very different aspects, and credibility is core in asylum proceedings, right? It's everything, right? And also the country of origin is everything, right? So this is one way. Another way, for example, that has been experimented a lot is doing a language test. So you would talk to a system, they would make a recording, and then based on your accent and how you speak, basically, it would determine, again, where you come from.
Yeah.
So there are different ways, again, in which this can be done, but this is quite worrisome for many reasons, and this is what I try to untangle as well. Yeah. So first of all, from a legal doctrinal perspective, I thought it was important to first of all understand how different overlapping layers of law and regulation offer what kind of protection. And from a legal doctrinal standpoint, if you take into account, the AI Act and the GDPR on the one hand, on the other hand, if you take into account, of course, EU law on asylum procedures and national law on asylum procedures, of course, you have certain standards with certain rights, and that's one thing. But then in practice, things don't work that way. So in practice, what our research found out is that there is a de facto huge lack of involvement of the person that is affected by the system. So huge lack of meaningful ways to participate. Most of the time, the asylum seekers are forced to hand out their mobile phones. Yeah. So there is also this aspect, which is highly controversial. And again, a lot of hype on these systems. And from an evidence perspective, I think you would agree with me that here it's not just a question of accuracy. So let's leave that aside for a second, but it's a question of evidentiary relevance.
Yeah.
How can you use my mobile phone to prove that I come from a certain country? Yeah. Like, how can this be suitable, right, to prove the effect, which is my country of origin.
Yes.
So, and this is highly controversial also because we do know from research that, of course, so asylum seekers, by definition, they move.
Mm.
So it's not so linear. I come from this country and now I'm in Germany applying, you know, for international protection.
Yeah.
I did that. I traveled, right?
Yeah.
So that's one point. The second point is, of course, they may also exchange funds. They may lose funds. So in that sense, it's not even about how accurate the output is. The question is the zero question: is this system suitable to prove a fact? And in my view, that is not.
Yeah, I agree with you. Yeah. Yeah.
So these are very, very interesting questions, I think, and it's something that, you know, most of the time from a legal perspective, it's not just the problem in the law. So we do have in the law, for example, the qualification directive sets the principle of collaboration. So you need to, you know, look at evidence in collaboration with the asylum seekers. We have, of course, fundamental rights, principles, right? Duty to give reasons, of course, allowing people to participate. We have principles of fairness, transparency in the data protection framework. So we do have principles in that sense. And actually, the legal framework is becoming more and more complex and layered. And that was also legally doctrinal challenging to disentangle and understand also how different sources of law come together. But at the end of the day, law is not just what is written in the books, right?
Yes.
Law is also made of people, is made of institutions. It's also made in that sense of data protection authorities that have the role to monitor on data protection issues. And this is at the core, right? And so in that sense, I found more problematic the practice of the law than the law in itself. But that's my take on it.
Yeah, no, for sure. But that's also a very interesting insight, right? Because I think that you touch upon, well, first of all, you touch upon a sector that I think we should all be paying more attention to, considering the recent developments in the migration policy of the EU, but also of individual EU member states like Italy, for example. You mentioned, for me, there are 2 points that kind of stand out from your study and from what you mentioned so far, is that on the one hand, there is the decision to rely on AI outputs, as I call it, stupidly, that is, automatically, without necessarily any discernment that is being exercised or assessment of the trustworthiness and, again, accuracy of the AI output. But also, on the other hand, there's the issue of effective participation and collaboration, as you say, in the field of migration, with the addressee of the outputs. So the addressee has to have the procedural means to say, this is not accurate, this is not trustworthy, please trust me, or I can allow me to prove otherwise or through other means, So do you think that the lessons that we can draw from the application of AI systems in the field of migration can be applied in other sectors as well? Are we likely to encounter the same difficulties, like this reliance on whatever the machine says, even if it leads to sometimes catastrophic consequences? And I'm thinking of a few cases, in terms of like risks to health, safety, et cetera, but also, should we, on a more general scale and across sectors, think about how to enhance and improve the participation of the people who are concerned, who are in the front lines, as it were, from the decisions that are made by AI. So, what are your thoughts on this? Like, is there a lesson to be learned from migration law?
Yes, absolutely. There are many lessons, and thank you so much for raising these points. I also think that the migration field is highly critical in the sense that coming from my research on criminal justice, where I saw quite some resistance actually towards the introduction of these tools on a societal level. I did not see the same in the migration and asylum governance field. So
Yeah.
scholars like Petra Molnar would make the argument, and I agree with this, that migrants are used as testing grounds. So we're using the migration field as a test, right, for these technologies, which is, of course, something that we need to resist and condemn. So that's one thing. But of course, I think the lessons that can be learned is, on the one hand, again, what is the role of procedural law? And I think the role of procedural law at its core is to balance power, to balance the power. I mean, in this case, I'm mainly a public lawyer, so I'm talking more about power between the state and the individual in these cases. So it is the role of procedural law to set standards so that it's not a public authority that needs to take the decision, should we use this system or not? But it needs to fulfill center standards. So in my view, that's also the role of procedural law, to set boundaries and standards for this type of evidence. So that's a major lesson in my view. Another lesson is conceiving procedural law not just as a doctrinal construct or as a product of law, but as a broader ethical principle that pursues certain values. And these values, when we think about dignity, when we think about a dignified treatment, respect, and also trustworthiness, right? Procedural law is core to achieve these values. But in order to achieve these values, I mean, what we also know from psychology studies is that procedural fairness matters when people perceive a procedure as fair. So that's what is important. Also the empirical side of things, also the perception of fairness, because that has instrumental and non-instrumental values. So conceiving procedural fairness also as a means not only to achieve more accurate outputs or more accurate decision-making, right? But also to allow people to, follow the law, have a trustworthy relationship with the state, with public authorities, and overall, increasing justice in the system, if you want. So, and I think the perspective of people is not sufficiently researched and taken into account. And when we think about AI systems, you do have the feeling that you are being treated as a number and as a statistical number, actually. So you're a percentage. So it reminds me of the amazing piece by Beans and Beal. It's like treating human as a percentage, right? And that's something that we need to reconsider. And I think that's the role of procedural law too. So I think the lesson is we do need to think about meaningful way in which the person affected by the system can collaborate and can cooperate and can also have a say on how on the output of the AI system. But then, of course, there is a whole set of different challenges because of the technical complexity of these tools. And simply because, at least in criminal law, most of the time you would need an expert. And an expert, like a technical expert, also is extremely costly, right? So we need to think about ways in which we can allow people to actually to have a say and participate. And I think that's really what also looking into migration and asylum is really teaching us. And the third point is generally, I think we need a more critical engagement with AI. Not take for granted that they can actually do what they claim to do, but be more critically engaged and think about different ways in which we can also prove facts without necessarily using AI systems. I think that's also a corollary of the right to privacy, right? When you can prove something, for example, I don't know, mobile phone cases. If I have another document, which maybe is not a passport, but I don't know, a marriage certificate, a birth certificate, why not using that rather than AI system that looks through my whole mobile phone data That's also a corollary of the right to privacy, right?
Exactly.
So maybe just think, like, apply the principles that we already have, and the human rights framework, the fundamental rights framework is an important source of for these, and make that work in the age of AI, and try to, lower the hype towards these tools.
Yes. Apropos making it work, and also making it work through regulation. And I kind of liked what you mentioned earlier, that there is the law and then there's the practice of law, and there might be a bit of dissonance in terms of how the law ought to apply and how the law is actually applied. So, this is a question that I have the habit of asking all of our guests, and that's their opinion on the regulation of artificial intelligence, in particular in the EU. I know we have privately had conversations, of course, about the AI Act, but I just wanted you to kind of share your opinion with us about the AI Act as a substantive regulation, and then kind of follow up with the AI Liability Directive and revised Product Liability Directive as the procedural pendant of the AI Act. So what do you make of these instruments?
That's a tough question.
I know.
So I think I would like to make 2 points. So the first one is that when we think about the AI Act, from as a legal scholar, as we are, we also need to take into account the fact that law is the result of a political compromise. And the AI Act is particularly interesting in that sense because it has changed so much throughout the legislative process, because it is very ambitious, and therefore it makes it complicated to translate all the policy objectives that it aims to achieve into law. Which has to be abstract, which has to be coherent. And it's very difficult, especially with a piece of legislation that is 200 and plus pages long, where also there are very different policy objectives, not necessarily conflicting. I also do not necessarily buy all the time the argument that if you want to protect fundamental rights, this is kind of it's conflicting with the idea of protecting innovation. I don't necessarily agree with that, with this kind of dichotomy. I don't think that's a dichotomy, but of course the AI Act pursues different policy objectives. And I think probably one of the most conflicting one was the idea that member states throughout the legislative process were putting a lot of resistance towards the competence of the EU to regulate precisely the fields I'm interested in, which is criminal justice and migration and asylum governance. So if you look at the AI Act now, you almost see 2 regulations, right? The AI Act for everything, and then the AI Act for criminal justice, law enforcement, migration, and asylum governance. And again, this is a result of a political compromise, because the EU is a complex actor, is a complex thing.
Sure.
So in that sense, we need to bear that in mind. Bearing this in mind, my way of looking at it is EU regulation on AI is a means rather than the end. In my view, it sets minimum standards. It's not the ceiling. It's actually the starting point. In my view, at least, everything I'm saying regards the areas I'm interested in, which is public law, criminal justice, law enforcement, asylum and migration. So one of the biggest critique, for example, of the AI Act in those fields has been, well, there are not sufficient prohibitions of systems that we know are highly controversial in the field of law enforcement. Live facial recognition technology is one of that, or predictive policing, highly controversial AI systems, so on and so forth. There are many exceptions, which, I totally agree with, but this does not mean, in my view, that member states cannot play a role in increasing standards of protection. So that's why I see that as, a minimum standards in the EU, a market-driven regulation with some elements of fundamental rights law rights, remedies, all great, fantastic, very happy. It's there, the fundamental rights impact assessment, everything is fantastic. Now, also accompanied by the other frameworks you mentioned, we will see again how that will end up, because the AI liability directive, like the AI Act, can completely change throughout the legislative process. We will see, but I see it as an important EU response, which looks at AI as a product, and I'm fine with that view. But then, when we look into AI into specific high-risk areas, such as criminal law, law enforcement, public administration, we cannot just conceive AI as a product. I don't think it's the right way to look at it. So there is one layer of regulation, which, is fine. And the challenge, in my view, will be to, first of all, legally, doctrinally disentangle all of this. So the AI Act, how is that going to work? In addition to the AI liability directive, in addition to the product liability directive, or also with the platform work directive in the field of, labor law, how all of this is going to communicate with each other and with the data protection. So lots of work for legal scholars for the years to come, in my view. And then the second level would be the enforcement. So now we have tools. How do we make it effective? So when we think about, effective judicial protection, effective enforcement is, again, to go back to the point before, not just the law, but it's also the practice of the law. And in my view, it has to go through AI literacy of people that actually use these systems. So this, very abstract image we have of who is the user. The user can be you, the user can be me. Every time we use ChatGPT, we are a user, right? In that sense, public authorities, when they use whatever AI systems, they are the user. And so we need to have sufficient AI literacy in that sense, raise awareness also at the individual level on how I, as a person affected by this system, can challenge it. So, and I think that's something that the GDPR did very well, in my view. So raising awareness about our rights. We need to control our data. So with all the flaws of the GDPR framework that we are seeing also at the enforcement level, I think one of the most amazing thing about the GDPR is that it did raise awareness that data protection matters, especially on an individual level. I think, my generation in particular, I saw, internet and Facebook when, for example, Facebook, I was a teenager. So for me, it was like, a folder in my computer. I was just putting pictures and pictures and pictures and pictures without really understanding what privacy is. And I think the GDPR changed that in our awareness. So I hope the AI Act will do the same. That's my point. So I think, everything is great, but we need to really contextualize what these regulations aim to do, where they come from, which is, political compromise, and how we can leverage them for the best. So I think the time of critique of the AI Act was the right moment to criticize it was throughout the legislative process. Now it's too late. And we need to make the best out of what we have by taking into account that there is still room for member states, in my view. So if a member state wants to prohibit predictive policing because incompatible with their constitutional values, that can be done.
Yes, I agree with you. Well, I think this is a can of worms that if we open it, I think we will be chatting for about 2 or 3 days, because also in Liège, at the Center of Excellence, we've been known to be someone critical of the AI Act as a choice, as a regulatory choice, right? But also of the AI Liability Directive and Revised Product Liability Directive. But I will say this though, and one of the reasons why I am so very, very thankful to you is that you also, while you were at Hertie School, you set up a platform that centralizes kind of seminal key cases, judicial instances that address issues dealing with new technologies, in particular artificial intelligence. And this was, of course, a blessing for me, very selfishly for my own research, because at some point, as you said, when we were talking about the AI Act, when the AI Act was still art in the process of making, there was just a lot of speculation, I thought, in scholarship, about what can it be, and so all of it seemed a little bit disconnected from practice and court practice, which I think court practice in particular, which is important for us to kind of have a clear idea of what are the challenges that AI systems raise vis-a-vis procedural fairness. So I wanted you to talk a little bit about the platform that you created and how that came about, and how does it work? Of course, we will kind of link the platform with this podcast, but just if you could just say a few words about that and how the idea came about and how it was executed later on.
Thank you. Thank you so much for this. Actually, it's a project I'm particularly proud of. It took many years to make it, to launch it and make it real. But it's a project I truly believed in, because when I started to do research on this, case law was pretty scarce. And then we saw a new wave of what we call tech litigation. Not only Europe, but globally.
Yeah.
So, and I was using these cases for myself to inform my thinking, get inspiration, understanding how judges are dealing with critical questions. So I started to collect it on my own, and then we had this idea with the Alpha project, and we got, of course, a grant for making it, for launching it, to create an actually publicly available database, which is called the Tech-litigation database. And the database collects case law on new technologies, especially right now more specialized in the public law field, broadly speaking, for the moment. But we will also see how to expand it. So it's about case law on new technologies, particularly AI, in the public law sphere more broadly, globally. So it has a global scope, and that's something that was, I think, very important to also go away from a very Eurocentric vision on these topics and look into how courts globally are addressing these issues. So if you look at the cases in the database, you will find cases from Asia, you will find cases from Latin America. In particular, for example, Brazilian courts have been very active in the field of facial recognition technology. So super interesting case law from all over the world, South Africa, for example. So very, very interesting, and can help us understanding how judges are approaching these questions. And I think one trend that we see, and I thought it was also important to reconnect to the previous question, is that judges are being, in my view, extremely creative in interpreting fundamental rights and adapt them to the digital age. So not necessarily the courts approach the questions, for example, of evidence and access to evidence and transparency, what we call explainability, as in, well, we don't have a specific regulation on this, so I cannot grant you access. No, the reasoning is, well, you have a right to a due process, or this is the Anglo-American, let's say, terminology, or in Europe, you have a right to procedural fairness, to a fair trial. Therefore, you must access AI evidence. It's simple as that, right? So, and when you read these cases, you're like, wow, courts are giving meaning to fundamental rights and adapt them to the digital age
Yeah.
without necessarily going through regulation. Now, I'm not saying that regulation is not needed. I will never make that point. I think it is important, and regulation needs precisely to do that, to translate into concrete laws and rules what a fundamental right says. So that's very important. So I'm very grateful that now we have a right to explainability that does not only apply to the very strict cases of Article 22 GDPR. I'm very grateful for that. But at the same time, when you look at these cases, you see how judges are really creative in the interpretation of broader principles and how we can use that. Another case, which I think is quite a landmark case, it is long, but in the database, we focus only on the paragraphs that are important on this case, is Ligue de Droit by the European, the CJU, the Court of Justice of the European Union, where there are many points that I think are super important. One of which is the idea that they derive a right to interpretable AI, so interpretability in AI systems, from precisely fundamental rights.
Yes.
So, they say, I don't care, what interpretability means in technical terms. So I'm not going to tell you which techniques that is, but you need an interpretable system for the principle of legal certainty, for the public duty to give reason, and for the rights of the individual. So AI system must be interpretable, full stop, when you use them as evidence. So which is great. And I think we need to remind ourselves also of this important case law. And this is precisely what the database aims to do. And this is the biggest trend I would see. The other trend that I think is important and is a big disclaimer in that sense is that litigation in this field is extremely hard. So before going, I think in the cases that we collect, we still do not have sufficient cases to meaningfully address the question you have. And your amazing research when you say, how can you prove that the algorithm discriminated me? Or how can you prove that the AI system is inaccurate in my case? We are one step behind. And the step behind is that people are trying to argue, litigants want to argue, I don't even am certain that the system was used in my case. I guess that is. But if that's the case, can I have a say? Can I challenge it? Can I have access to information about it? So we are really one step behind, and this is highly problematic in my view.
Oh, for sure.
Because we still do not have sufficient litigation in this field. And actually, most of the cases you will see in the database are brought by civil society organizations, which means what? That we as individuals are not sufficiently empowered to challenge these tools because of lack of transparency, because of lack of understanding, because of lack of awareness, perhaps because of lack of law in some cases. And this is a problem. So,
Yes, exactly. Oh, wow. Francesca, I really feel like you've said so many things, and I really feel that, I have so many questions that I think we could sit here for like 3 or 4 more hours. But I'm afraid we're approaching the end of this amazing podcast. Time flies. But just to kind of pick up on the last point that you mentioned, indeed, I think there is a problem or an issue with knowability, right? Of just being informed that your data was used for XYZ in XYZ automated processes, but also, in my view, with this multiplication of various legislative instruments, so there's, for me, also an issue of like which legislative provision should I rely on in order to launch an action, right? Because if personal data is like, if you take a topical example like non-discrimination, depending on the facts of the case, EU non-discrimination law can apply, the GDPR can apply, the AI Act can apply, and when the AI liability directive will enter into force, that can also apply. So how do you launch what is the relevant legal provision for you to launch a claim? But anyway, these are kind of open questions that I'm sure, since we know each other very well, we will have the occasion to talk about, privately. But with all of the amazing things that you mentioned, and thought-provoking things and insightful things that you mentioned during this conversation, what is the message for the researchers, but also to anyone who will listen to this podcast? What would you like to tell them?
Yay! So that depending on the audience who is listening, hi dear listeners. So first of all, I think generally my message is that law needs to be, I think, braver and bolder in setting concrete and tangible limits to AI systems. And I'm not saying this because I think AI is bad. I also do not believe in this dichotomy, good versus bad. It is not, no, that's not the right way to think about this, in my view. But to truly understand the functionality of AI systems and how we can use them for increasing fairness and justice. So one, I think, very interesting line of research is looking into AI systems for making human decision-making more fair. So the biasing tools and things like that. I think that's something that we need to focus surely more on. So my point again, yes, would be law needs to be bolder. We need to be braver in setting concrete limits and have a critical engagement with these AI systems. For researchers, I think it is very important to look into interdisciplinary, or at least stimulate interdisciplinary efforts when we consider procedural fairness AI. So at different levels, law and more legal doctrinal ways or normative approaches to procedural fairness, then we would have more empirical insights, right? So how do people perceive when we use AI systems in a process by public administration? Does it increase trust in authorities or vice versa, diminishes trust? And how we can link the two. I think this is a very important direction of research. And then finally, I think bridging also vocabulary and understanding between computer science or data science and law. When I talk about interpretability in the law, what do I mean by that? So we need to merge. And I think it is the role of legal scholars to set concrete standards that are required by law. And on the other hand, have a conversation with data scientists in understanding, okay, what is this specific explainable AI technique? And is it in line with these standards? Does it fulfill these requirements that the law sets? I feel like sometimes we don't talk to each other enough, and we can develop amazing techniques that from a legal perspective are simply not enough, right, to fulfill all the requirements. So this is, I think, super important. So more interdisciplinary research in that sense, I think is very important. And that, yeah, of course, procedural fairness matters.
Yes.
It does matter. It does matter. And raising awareness in that sense, I think, is super important. And that's, I think, is the last point, the amazing role of civil society organizations. They're doing incredible work, and I think they are not credited enough for this. So that's very important, but also the role of practitioners, also the role of authorities and data protection authorities as well, in really giving real meaning to these rights. We have rights, but we need to bridge the gap between the law and practice and make this meaningful enough. Yeah.
Yes. Powerful message, powerful, true message that I can only agree with. So, Francesca, many thanks for
Thank you.
this chat, for sitting down with me, for finding the time to sit down with me. As you know, I'm a big fan of your work, and I follow. I follow
I'm a big
your
fan
work.
of yours.
Yeah, I follow your work, and will continue to do so. And there will be future occasions within the Center of Excellence where you will be included, but more on that in due time. So thank you very much again, and I for this amazing and insightful conversation. And I hope that we will have you as an expert featured in some capacity in the center soon.
Thank you so much. Thank you so much. And also a praise to the center because, it's really important to do research and from many different perspectives. And I think you're doing an excellent job on this. So
Thank you.
a praise to the center too. Thank you so much for the invitation again.
Thanks.
Thank you for watching an episode of the JUST-AI Jean Monnet Podcast, brought to you by the team of the JUST-AI Jean Monnet Center of Excellence and supported by the European Commission through the Erasmus Plus program. Keep an eye out for upcoming podcast episodes where experts in the field of AI will delve into the significant risks posed by these technologies and propose potential solutions. Stay tuned for many exciting and insightful discussions to come.